All right. So with regards to this, the court had heard the evidence in this case. Is there any remaining argument from either parties?
Just from the defense.
Oh, well, let me go on the record if you have remaining argument. I was just trying to see where we are. The court is calling 2025 CR 010203 State versus Fabian Singh. And if I could have parties announced for the record for the state.
For the defendant.
And are you Mr. Singh? All right, we had a motion to suppress hearing. The court heard this case, the motion to suppress at least on, I think, December 8th or December 9th. Is that correct?
Something like that, yes.
Yes, okay. And we're here for the court to make its ruling. And I know at that hearing, there were certain things that both parties stipulated to and agreed upon. All right. States has informed the court that they have no further argument. Defense, it's your motion. Do you have further argument?
Yes, Judge. Focus in this case is on the search of the defendant. The court will recall that officers responded to a welfare check call where the defendant was initially seen on the roof of a parking garage. When the officers encountered the defendant, he was on the sidewalk. They detained him and put him in handcuffs. The officers testified that there was no evidence that the defendant was suicidal. And in fact, the incident detail report indicated that the individual on top of the parking garage was not wanting to jump. However, the aggressive nature in which the officers approached the defendant, they immediately grabbed his arms, put him in handcuffs, and started patting him down. And they went beyond the initial pat down into the pocket of his hoodie and found a bottle of twisted tea. The pat down is legally allowed for search for weapons, not for alcohol. There was no indication, according to the officer's testimony, that the defendant was intoxicated at the time of the pat down for weapons. It's clear from the video that they just immediately went into his pocket for that can of twisted tea. There was no open container at all found. There's no indication of intoxication. So it's our position that from the very beginning, their intent was to fully search the defendant and find out what he had on his person, well beyond what was necessary for their safety.
All right. So, Mr. Singh, I want you to know that I've heard all of the evidence that's been presented to the court. My job is merely to listen to the evidence that's presented on motions to suppress, then make a decision based upon the evidence that's presented to the court. Do you understand? And the reason why I wanted this brought back is because I always, even though I say I know the law, which I do, I always like to make sure there isn't something out there that's brand new that maybe somebody, some appellate court just ruled on yesterday, right? I remember and I recall that I did ask parties if there was any case law that said that someone could not be arrested or was not allowed to be arrested for a Class C misdemeanor, to bring that to the court. And I have not received any emails to that effect. So the court will make its ruling. The court will deny the motion to suppress. And counsel, we're off the record. Counsel, do you have all the discovery in this case?
Yes, ma'am.
Okay. And state, were you able to tender an offer?
Oui.
Okay. How old are you? All right, Ms. Ferguson.
Yes, ma'am.
If you can bring this back in 30 days for a plea deadline date.
I can do January 22nd, Judge.
All right, we'll come back on January 22nd. Because of your age, I want you to have a chance to internalize everything that your attorney is going to tell you and think about the consequences or the potential consequences on either decision you make. All right, thank you. And thank you for always dressing appropriately for court. Once you sign the reset form, you'll be excused. All right, Rose Padilla, that's who you're already on?
Yes, Judge.
All right, come forward.
Judge, we thought, we thought we had an agreement, but since and the only reason we fled through is because we thought we had an agreement, but since apparently, that's not the case, so we'd like to withdraw that agreement.
Okay,
I know. But you were here.
all right, sure. Her plea of not true will stand for violations 10, 21, and 23. And you all come back here for a contested hearing.
When do we come back?
Nora, when can we fit them in for a contested hearing?
I can do the January 7th.
All right, January 7th will be your contested hearing.
Thank you, Judge.
Thank you. Valderas,
Afternoon, Judge.
good afternoon. All right, have you all reached an agreement?
No, Your Honor, the plea offer has been rejected.
Okay. Norm, I need a jury trial date. How long will this last?
I apologize, Your Honor. I would expect at least 3 days for the state's cases.
All right, 3 days, Ms. Ferguson.
Yes, ma'am. I can do March 24th.
All right, your jury trial date is going to be March 24th. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have the plea open to the court. Do you understand?
Yes.
All right, just have a seat,
We
counsel.
also have one more matter. We were asking the court to consider modifying his bond condition from full house arrest to partial house arrest or tracking only.
All right, have you all filed a motion?
We have.
They have, Your Honor, the state doesn't have an objection upon proof of employment and verification of employment hours to pretrial services.
Okay.
To modify it to GPS parcel. We would object to traffic.
We would ask the court to allow him to go out and look for work, Judge.
Well, nowadays, your employment, you do it online. So,
He's been doing that. Yes. He has tried.
so the court will allow employment, partial GPS for employment only with proof of employment and your work schedule.
Just for clarity, Judge, he needs to find a job first before he can.
He needs to, I mean, he can do it online.
He has, Judge. He's been trying.
Okay. All right, and I need from the parties an acknowledgement of discovery signed completed, and I'll sign it. All right, thank you.
Except that last week.
Thank you.
Thank you, Judge.
Thank you.
Happy holidays.
Oh, you too. Christopher Falk.
Good afternoon.
Good afternoon. How's it going?
Good. Let's see.
All right, today is plea deadline date, and I'm assuming you want your jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date. How long do y'all expect this trial to last?
3 days.
All right, jury trial date, criminal trial division, 3 days.
Family violence.
I'm sorry, family violence. Thank you.
Any date, Judge.
All right, March 24th.
Thank you, Your Honor.
And Ms. Ferguson, Mr. Davidson is requesting that Mr. Porter be appointed as his second chair. All right, thank you.
Thank you, Your Honor.
You're welcome.
Judge.
Oh, and counsel, you'll need to do a clothing exchange with him. And according to the jail's rules now, it needs to be done 72 hours in advance.
Okay.
Not more than 72 hours in advance and not less than 72 hours in advance. All right, thank you. Stephen Lamone. Are there any applications in this case?
Yes, Your Honor, for community supervision.
All right, Ms. Abrams, application. Court is calling 2025 CR 007431, State versus Stephen Lamone. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Renee Munoz on behalf of Mr. Limon.
All right, just one. So everyone in the box, you all need to whisper. I would appreciate it if y'all would whisper in the box, and then when you're before me, don't whisper.
Mhm.
All right, we're back on the record. And are you Stephen Lamone?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lamone, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lamone, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Limon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison, $0 fine, no application for deferred adjudication. State recommends community supervision. There's to be restitution to Trinity Key in the amount of $1,806.94. Ignition interlock for half the term.
Or an affidavit of non-driving.
Thank you.
I believe the defendant may not have a contact.
Okay. Or an affidavit of non-driving. And what I can tell you, the court will add to that, no access to any vehicles.
Yes, Your Honor.
And a 2-year driver's license suspension. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours community service restitution, 10 days in the Bexar County Jail as a condition, participation in successful completion of VTC and inpatient treatment through VTC, DWI education and victim impact panel. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Number states one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, if you may.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Dumont has some issues relating to substance use, Judge. All of his previous cases have been DWIs. He has not been afforded in those other DWIs the chance for treatment to get a handle on his issues, Judge. He was screened indeed eligible for veteran treatment court. It's a very intensive program, which I believe Mr. Limon would benefit from, being that his military service and the issue he incurred because of his military service are tied with the issues he's currently dealing with now in terms of dependency issues, Judge. So we're respectfully requesting this honorable court follow the negotiated plea bargain agreement for probation with the condition of veteran treatment court, Judge, Furthermore, if the court would consider in terms of the 200 community service hours, if he does AA and A classes, he may be afforded the opportunity to work his community service hours through the use of those meetings. And if the honorable court sees fit, he has been in custody pending the resolution of this matter. If he could be granted the 10 days Bexar County jail, being the time he did upfront in relation to this case, Judge. Furthermore, he can reside with his mother at her address, and we're requesting this honorable court sees fit for him to be on full house arrest GPS, no access to any vehicles, and that way BTC can set him up with treatments, hopefully at an inpatient facility to get a handle on.
All right, this is what the court is going to do. There's to be a referral to VTC. My understanding, he's already been accepted.
That's correct, Judge.
All right. So instead of referral, I'm going to order VTC. There's to be 10 days in the Bexar County jail as a condition of probation. Once you are placed on probation, your case will be transferred to the Veterans Treatment Court. And if they make the decision that you're not to serve the 10 days, then they can make that decision. The reason why I'm doing that is because if they want inpatient treatment, they may transfer you from the jail and just have someone to pick you up to take you to the inpatient treatment facility. Regular reporting by Zoom or in person, regular random UAs, ignition interlock for half the term, or he can provide an affidavit of non-driving and no access to motor vehicles. There's to be 2-year license suspension, 200 hours of community service restitution. I'm going to allow him to deduct an hour from those community service restitution hours for every sober support meeting he completes. DWI education course, DWI intervention, victim impact panel live, field visits 1 time per month until further notice, full GPS, waive fees. There's to be restitution of $1,806.94 to Trinity Key. Probation is there, and there's to be 8 years in the prison, suspended and probated for 5 years. And there's a $0 fine. Probation, is there anything else? No, he's already been accepted into Veterans Treatment Court, so they'll take care of that. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Veterans Treatment Program, that's a good program for you, right? If you successfully complete everything, when you graduate, if I'm in town, you let me know you're graduating, I'll show up for your graduation.
Thank you.
Okay. So which branch did you serve in?
Marine Corps.
Okay. Well, you can do this, all right? If I didn't think you could do this, I would have read that report, and you know what I would have said? I would have said, I'm not following this agreement. So I know you can do it. The state wants you to be successful. Your attorney wants you to be successful. Even though your case is going to be transferred to them, and they'll be in charge of whatever conditions they set for you. If there's anything else you need, you can always come back here if I'm here, all right? All right, good luck to you. You're welcome. Thank you. And Renee, if you let VTC know that if they don't want him to do 10 days, it's completely up to them.
Yes, Judge, I'll update them that the probation is granted at that condition. I'll make that request. Thank you for reminding me.
All right, thank you. All right, are you all ready to proceed on the MTR?
Yes, Sean.
Court is calling 2021 CR 11554, State versus Richard Cantu. Can I have parties announced for the record for the state?
Michelle Savetta for Mr. Guthrie.
And are you Mr. Cantu?
Sure.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it? All Are you the same Richard Cantu is placed on deferred adjudication in 2021 CR 11554 for the offense of obstruction or retaliation on September 16, 2024 for a period of 3 years? Is that you?
Yeah.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Richard Cantu did then and there fail to report to the supervision officer as directed for the months of August, September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We would abandon the remainder.
Any objections to the waivers? Did you understand by pleading true to violation of condition 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No. Are you pleading true to number 4?
True.
Do you understand? No. Listen to me. Are you pleading true to violation of condition number 4? Yes or no?
No. Don't know what I mean.
So this is what it means. The state is saying that you did not report. Do you understand that?
Yes.
Did you report?
No, I couldn't find the.
Nope. I just want you to answer my questions. All right. So you have just pled true to the fact that you didn't report. Do you understand that? Now, whatever agreement you've worked out with the state, I don't have to follow that. Do you understand? I can send you to prison for 10 years. Do you understand? So knowing that I can send you to prison for 10 years and up to a $10,000 fine, do you still want to plead true? Yes or no?
No.
All right. He doesn't want to plead true.
True for the probation office. I could not find the probation office. Yeah.
All right, so here's the thing. This is his second motion to revoke. I know he know what's going on here. So I'm going to explain it to you again. And if you wanted to proceed with saying yes, no, not answer my questions, we can do that. And this will be recalled for a contested hearing. The state will bring in a probation officer or whatever witnesses they need. Do you understand?
Yeah.
Now,
I could not find.
now listen to me. Are you pleading true to not reporting, yes or no?
No.
All right, so we need a contested hearing. All right. What date for a contested hearing? Failure to report.
I can do the 7th
Do you want to do the 7th
or the 9th.
or the 9th? Now it's up to you. If you want to bring it back for another day, that's fine.
We do second.
All right, we'll see you back on the 15th. The state will call whatever witnesses they need to call to seek to prove the failure to report. And what I can tell you on failure to reports, usually the person that needs to be called is the probation officer. And that probation officer is going to come in and say, either you reported or you did not.
I did not report. So I know I didn't report to nobody when I got released the 3 times.
So I don't understand why you're not asking my questions.
But to be saying yes, I did not see no one, or no, I never went into the door. I'm saying that I never went to see the probation officer because I never saw him. I never got reported to see him.
Mhm.
I never got his address or his phone number to see.
Mhm.
Yes, I want to move forward with my case. I want to take it to. I want to take it all the way, like guilty and not guilty. I play guilty. I pay no contest also. But I never saw my probation officer when I got released. I never had ever seen.
You want to talk to him some more? All right. Court is calling 2022 CR 1107 State versus Angel Cantu. Could I have parties announced?
Rick Pena for the state of Texas. Warren Gary for Angel Cantu.
And are you Angel Cantu?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Angel Antonio Cantu who's placed on deferred adjudication in 2022 CR 1107 for the offense of indecency with a child's sexual contact on August 25th, 2022 for a period of 10 years? Is that you?
Yes.
State.
Yes, Your Honor, violation condition number 13A. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to having internet identifiers on Discord, Kick, and other social media platforms. Violation of condition number 13.
How do you plead to that? True or not true?
Sure. Violation condition number 13B. On or about the 16th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, in that the defendant failed to progress toward reasonable treatment goals and was terminated from treatment in violation of condition number 13B.
How do you plead to that? True or not true?
Violation condition number 13JA. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there failed to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to accessing the internet on an unmonitored device in violation of condition number 13JA.
How do you plead to that? True or not true?
True. Violation condition number 13L. On or about the 11th day of
Let me just stop you all. Are you all doing 13L but not 13F?
13F and 19 are going to be waived by the state.
Okay. Do you really need 13L?
You can waive 13L as well.
No objection, Judge.
All right. Did you understand by pleading true to 13A, 13B, 13JA, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to 13A, 13B, and 13JF?
Yes, Your Honor.
Court will find 13A, 13B, and 13JF true. Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion, revoke the defendant's probation, adjudicate him guilty, and sentence the defendant to 8 years in prison.
All right. Why should I follow this?
So Judge, Mr. Cantu so these allegations arrive from Mr. Cantu's own statement. So he was self-disclosing of these things during the process of which he was getting treatment for under the sex offenders program. He had been asked by his counselor, through the various ways they go through counseling, how are you doing? What's going on? He self-reported these incidences. The thing that what I understand from how I've looked at this case is that my client has had struggles with doing probation. I think ultimately probation is good because it helps us find these issues where we have problems that kind of relapse up. I think given that Mr. Cantu has indicated, we're here today because he's not hiding anything. He's not proud of what he did, and he has indicated to me that he understands that this is, it's not good, and he, shouldn't have been doing it in the first place, Judge.
Has he had contact with the complainant?
Judge, it is my understanding that he has not. I do have the mother of the complainant here is present. If you would like us to call her, Judge.
I mean, well, you talked to her. She's saying that he hasn't had contact.
That is what she said, Judge, and I understand that's only her statement.
How old is the complainant?
My mother. 14, Your Honor.
Okay.
Judge, 14 at the time of the
Can I get that? Yes.
All right. And I'm sorry, State, why should I follow your agreement?
Seems like contention of justice with this coming about. Fair prison sentence from the state point of view.
I'm sorry.
It's a fair prison sentence from the state point of view.
So what has he done on probation?
I'm sorry, his probation officer was here a little bit earlier.
Okay.
But according to the court summary, there has been 3 negative UAs. He was in sex offender treatment, but there was some issues there. As far as anything else, he was on the so moved caseload, but there's a total credit of $1,163 toward his supervision fees. But other than that, Judge, nothing.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will revoke, find you guilty, sentence you to 8 years in the prison. There's to be no contact with the complainant, no residing in households with minors, no contact with minors, and Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement? Oh, I'm sorry, I need that back. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Could I have his file back, please? Yes, ma'am. With the trial court certification. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Sure.
Sure. All right, good luck to you.
Thank you, Your Honor.
All right, so what is the status on the evaluation?
So Judge, one of the reasons it got reset was because Ms. Jeffrey was having her parole hearing in between last setting and this setting. She has had her parole hearing and they have decided to continue her on parole, but she is going to be sent to safe P.
Okay.
One of the questions the court has was she had been referred for further evaluation regarding DDRF, and so the court was going to consider that depending on what happened at the parole hearing. Now, given that she's been ordered for safe P, as courts aware, that's a super long program of 9 months, I believe it is. I would just ask that she be allowed to start her probation once she gets out of safe P, that she's already going to have.
No, I mean, she will be on probation here already. It's just that
Right.
she's going to have safe P.
As a condition.
Judge, I'm sorry. This is Caitlin.
Yes.
Okay, so Judge, there was you just signed an order and amended conditions for her to do DDRF.
Okay.
There was a Tacoma already completed, I believe, and you signed paperwork just recently, maybe days ago, for DDRF, correct?
No, I never signed for DDR.
Ms. Abrams, maybe I have it wrong in my system.
Consider if parole is going to continue her without any other conditions, if the court was going to allow her to do outpatient treatment as part of probation.
All right, if you can do me a favor, just confer with Ms. Abrams and I can take up the plea for Mr. Woodard.
Yes,
Matthew and Sariaga, court is calling 2025 CR 007924, State versus Matthew and Sariaga. Can I have parties announced for the record for the state? Defense?
David Andre Woodard for Matthew.
Are you Matthew and Sariaga? Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find the state is in compliance with discovery. Mr. Nsiriaga, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it? You're charged with aggravated sexual assault of a child. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge, and he was.
Mr. Siriaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application. There's to be Chapter 62 compliance, no contact with the complainant, and you're subject to the full range of punishment if you fail to, do y'all mean this to say fail to appear for sentencing?
Yes.
All right. Any objection to the court changing the word PSI to sentencing?
No objection from defense, Judge.
And state?
From the state.
And you will be subject to the full range of punishment if you fail to appear for sentencing. So your plea will still stand. It's just that your agreement will change to you'll be subject to the full range of punishment instead of 10 years. Do you understand? Sure.
So
No, this is what is going on. The state is opposed to the court granting you probation. You can still apply, but there's not an agreement. The state is not saying they want you to have probation. They're saying they do not want you to have probation. Do you understand? Now, with regards to you're not appearing, I'm going to give you a date to come back for sentencing. If you don't appear on that date, your plea bargain agreement for a cap of 10, which means that the state would only be able to ask for 10 years, will change to the state will be able to ask for life. Do you understand? Did you understand that to be your plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? The waiver of appeal paragraph just tells you whether or not you have a right to appeal certain things. It's this paragraph. Did you review that with your attorney? Did you understand it and sign it? By signing that, you're waiving your right to appeal. The only items that can be appealed are motions that your attorney has filed, and I've ruled on them. Do you understand? Counsel, have there been any such motions?
No, Your Honor.
All right. Then to what you're being charged with, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State, it offers State's Exhibit 1 and all attachments, Your Honor.
No objections, Judge.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, you may be excused.
Judge.
Did you review this document called waiver and stipulations? Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, today there will be no witnesses, live witnesses. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you requesting a PSI and TAP evaluation?
I am, Judge.
Is there a need for a mental health evaluation?
I believe so, Judge.
All right. I need a PSI, TAP, and mental health evaluation, Ms. Abrams and Ms. Ferguson. What date?
I can do February 12th.
All right. Once you sign the reset form, you are excused. I will base my decision upon your application upon any information that's given to me. All right.
so my brother, he's in the army. He's gonna like, how do I have him like get a contact with child for?
Oh, no. What will end up happening is you'll speak to your attorney about that. And whatever information you want me to know, just let your attorney know, and your attorney will let you know if they think it's appropriate for me to know about that or anything else. Just go through your attorney, okay?
And I don't want to do that.
I'm sorry, what?
That's one more thing.
Sure.
I'm trying to see if religion could go to my child's birth.
Oh, you'll have to speak with your attorney, and your attorney will have to file a motion for that.
Yes, and I asked him, said he was gonna talk to. Said he.
Okay. All right. And is the complainant the mother of this child? Oh, no.
What do you mean?
I said the complainant in this case. All right. Then your attorney, once your attorney confers with the state, the court will consider. All right, Ms. Ferguson, I'm sorry, what date?
February.
All right. So we'll be back on February 12th. Mr. Woodard.
Okay, thanks, Judge.
All right. Thank you. Once you sign that, you'll be excused. All right. Court is calling 2021 CR 11554. We're back on the record, and Richard Cantu. All right, Mr. Cantu, the last time we were here, you pled true to violation of condition number 4. Is that correct?
Yes.
All right. Did you understand by pleading true to violation of condition number 4, the court could grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yeah,
Knowing that, do you still wish to plead true to violation of condition number 4?
yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it is to grant the state's motion, revoke the defendant's community supervision and sentence him to a term of 4 years in the prison, and then the state would be taking into consideration clause number 2025 PF 43375.
All right. Is that your agreement?
It is, Your Honor.
Mr. Cantu, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right. The court will follow your agreement. Odyssey is slow. All right. The court will find violation of condition number 4 true. The court will follow your agreement, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served, take into consideration 2025 PF 43375. There should be no residing in households with minors, no unsupervised contact with minors. I'll state you may be excused. And the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? Yeah. All right. Good luck to you, sir.
Thank you, Judge.
Thank you. Oh, it's David Solomon Duenas.
Yes, ma'am.
All right. Court is calling 2023 CR 2677 State versus David Solomon Duenas. Could I have parties announced for the record
For the state of Texas,
and for the defense?
Raymond Martinez.
And are you David Solomon Duenas? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? This is incorrect. Let me see. This was a jury trial.
Yes.
Okay. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Solomon Duenas who was placed on community supervision by jury in 2023? Placed on community supervision by the court, which followed the recommendation from the jury, and 2023 CR 2677 for the offense of aggravated assault with a deadly weapon on January 23rd, 2024 for a term of 5 years. Is that you? State.
Violation condition number 1, on or about the 9th day of October 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, committed the offense of assault on violation condition number 1.
How do you plead to that? True or not true?
Violation condition number 2, on about the 12th day of September 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, did then and there illegally use a controlled substance, namely cocaine, in violation of English number 2.
How do you plead to that? True or not true? All right, state, call your witnesses.
This time, Your Honor, state will call Terrence Williams.
All right.
And Judge, before they call the number one, when they try to prove that one up, I wanted the court to be aware that we would prefer to have our jury trial on the number one violation.
Mhm.
And it's been indicted already. We're ready to go on it as soon as the court could, but because of the different standard of proof, I think in all fairness, my client should be afforded his right to a jury trial on that.
All right, we're going to proceed. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Terrence Williams.
All right, state, you may proceed.
Thank you, Mr. Williams.
Good afternoon, sir.
Could you please introduce yourself to the court?
My name is Terrence Williams. I'm a CSO for Thurs County
How long have you been a CSO with the Bexar County, Bexar County?
since 2025.
In your employment with Bexar County Probation, have you come into contact with someone whom you now know to be David Solomon Duenas?
Yes, sir.
You see that person in the courtroom today?
Yes, sir.
Could you identify him, please, by article of clothing that he's wearing?
Black vest, black long sleeves and glasses.
Mr. Williams, can you please tell the court when was your first interaction with Mr. Duenas?
September of 2025.
And at that meeting, did you go over anything with Mr. Duenas?
Yes, went over acting a series of
We get the
questions.
non-responsive judge. You just asked him, did he go over things with him? The answer is yes or no.
Yes.
What things did you go over with Mr. Duenas on that day when you first met him?
So some things I went over were his employment, place of address, and had he had any contact with law enforcement, the police, or any arrests.
And what was the purpose of that last question for having any contact with law enforcement or arrests?
The purpose for that question was to determine if he was violating any conditions under his probation.
And what condition of probation would that be?
Violations of committing a new offense.
No further questions this time, Your Honor. I'll pass the witness.
No questions, Judge.
All right, thank you. Is this witness excused or subject for recall?
Excused by the state.
Judge, I'm not really sure what role he plays in the overall scheme of my client's probation. I don't know if he's a regular probation officer or just, it was just that particular day.
Mhm.
If he's a regular probation officer, I'd like him to stick with that.
I understand this.
Okay.
All right, so if you could remain. Thank you so much, and thank you for your patience. All right, call your next witness.
Your Honor, this time state calls Miss Karina Luvano. If I may just check.
Sure.
Thank you.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna need to speak up so I can hear and the court reporter can hear. You can lower your hand, state your name for the record. All right, defense, you may proceed.
Mr. Duenas, do you recall the incident in October with Ms. Levano who just left? And the two, do you agree with her that the two of you were together in a living together relationship for 4 years or more? And you have a child together? Okay. What was your child's age at the time? Yeah, more or less, yeah. And how long have the two of you been living apart? Okay. So you knew that she already was in a new relationship, correct?
Sustained.
Did you know whether or not she was in a new relationship? And had you ever informed her whether or not you had proceeded to a new relationship? Okay. So was there any leftover issues between the two of you, or were you at this point separate and apart permanently? What do you mean by she had issues? You need to speak up. Like a speculation on.
All right, that'll be sustained. And I'm going to need you to speak up because I can barely hear you. I know the court reporter is struggling. All right, the objection to speculation as to the thoughts and feelings of the complainant, that will be sustained.
Okay, so what was the reasoning for you to be there that day?
She asked me that
called me while I was at work if I could pick up the baby. Share plans.
Okay, and did you agree to do that?
Yes, I was going to dinner with my partner.
Okay, and were you working that day? And so what time did you make plans to be there to pick her up? Okay. And so did you get to her apartment around roughly that hour? Okay. And what was her demeanor like or her behavior at the time when you first encountered her that night?
She was fine.
Okay, so everything is fine. Okay, and at some point did that change? And what caused that to happen? A little bit louder, Dave,
The
please.
baby was sleeping at my girl. She was tired and put her else. Then come back to her mom. I was off the next day.
How did she respond to that?
She said she already made plans and I was ready there for me to take her. And I told her that she was feeling real bad at her mom. Because I was very late. Says I was the girl in the morning.
So you didn't leave her upstairs to sleep. You actually picked her up and we're going to take her.
Yes.
What was your concern, Dave? Why did you not want to do that?
I've been home in 8 months, so she's not that comfortable with me again. So
Objective speculation, Your Honor.
Overruled.
You can finish your answer.
she not that comfortable. She has with she cries. And, so I didn't want that to happen.
Okay. And did you express that to her?
Yes. So she replied that she needs to get used to deciding to take her.
Okay. And at some point, did the tone of voice between you or her change? Okay. And then what proceeded to happen next?
And that I whatever I want. And
Objective state hearsay, Your Honor.
Overruled.
So she's cursing at you. She's upset with you. And what happens next?
she told me about money. She wanted money and how much spending rates with my concern. I gave her money to her apartment and helped her out.
Okay. So even though the two of you had separated, she's still living in an apartment that you're financially obligated to pay. Is that right?
Objective leading, Your Honor.
Overruled.
But so all these things start coming out from her complaints, suggestions, comments, whatever you want to call them, after you told her you were going to leave the baby.
Objective leading and relevant.
Overruled.
You tell the judge, David. Tell me what happens after you tell her that you don't want to take her in that condition she was in at the time.
Wow. Not giving up time for the help them. That's it. This part of she let me, so that made her mad. We just continued to argue back and forth on the kids. She was in a car with me.
Okay, so what did she do next? Okay, she grabbed your phone? Okay. So why was she grabbing your phone if you know?
This
Objective speculation, Your Honor.
Overruled.
Has she ever taken that tactic with you in the past when you guys have argued? Okay. Now, I asked her the question about whether or not she'd ever been physical with you. What is your answer to that question? Okay. And so when I say that, describe for the judge the kinds of actions she's taken against you in the past.
And on my head for the children and the fun of people I had nothing like that.
Now you say glass pan. Describe it for the court.
That's so
Okay, so it's like a dish that you would store food that's cooked in. Okay. Did it break? And what was the injury that it caused to you? And did you file a police report as a result of that? Okay. Is this the first time that she'd gotten to that extreme with you? So So that was the last day that the two of y'all were together? Okay. Now, you heard the way she described the way that you were acting that day, correct? She characterized it as you charging at her. Did you do that?
We're fighting over the phones. We discussed it. We didn't charge her.
So it was strictly the two of you. Were you fighting over your phone or fighting over hers or both?
Well, she had mine. Just trying to.
Okay. So at any point other than trying to get your phone back or taking hers, did you put your hands on her? Okay. She talks about being cornered in the kitchen. Did the tussle or the back and forth over the phones move around the apartment?
I'm not charged for the phone. She would walk back and then try to get my phone. We still was back and forth.
Okay. You heard me ask her about her 11-year-old. Where was she at this time?
Watching.
Well, when you say she's watching, where was she? So in the same room y'all were in. Would you say she was there the whole time? Are you on good terms with her?
Yeah. Objectless irrelevance, Your Honor.
Sustained.
To your knowledge, well, yeah, something else. Why did you leave after this all kind of, I guess, calmed down?
She gave me my phone back so I little kid. And I broke it. The daughter started crying and hugged her and everything. And I grabbed my phone and left.
Now, the phone that you broke, was that your phone or, I mean, who owned the phone? Okay. So she was using it, but okay. You understand that probably wasn't the best move. Okay. But did you throw it at her or strike her with it or anything like that?
My phone got left it here.
Okay. Now, since she's gotten this protective order, has she reached out to try to communicate with you?
Objectless irrelevance, Your Honor.
Overruled.
Since the protective, well, let's go back. Did you agree to a protective order with her? And when did that happen? Okay, so sometime after October. And you agreed to it in the sense that you signed off on, is that right?
Yeah.
Now, even though you got that order, has she still tried to communicate to you directly or through another person?
Objectless irrelevance.
Overruled.
Has she tried to get messages to you or to communicate with you even though the protective order is in place? Did she contact your family? I'll pass away, Judge.
State.
Mr. Duenas, you have animosity toward Ms. Luano, correct? I don't know what that word means. I can't hear you. I'm sorry. Can you turn towards me? I don't know what that word means. You don't like her really anymore, do you? I still love her. Mother of my daughter. I can't hear you again. I still love her. She's the mother of my daughter. Well, you have anger towards her, right? You don't have any anger towards her at all. So you just left because you just wanted to leave, right? Because it was a happy situation for you to leave, right? You were happy in doing so. You weren't angry at all at her because of what you're saying she did to you, right? From that day? From what day? Okay, well, let me help you out then. You were testifying earlier with Mr. Martinez asking you questions that you don't live with her anymore, right? Yes. If you had moved out, right? Yes, sir. You were angry in doing so, right? I was just sad that our family is broken, so I left. There's nothing I could do. There was nothing at all you could do to try and make things better, right? You certainly couldn't act better on your end towards her, right? I moved and made my decision to get away from her. Okay. So because of that, and you having to now live somewhere else, this is an inconvenience for you then, right? Oh. Okay. You have to make arrangements with her whenever you want to see the child that you have in common then, right? No, you don't. So you just go whenever you want to over there? You said yes or no, and I don't argue. Right, exactly. Those are arrangements that you're making with her to see the child, right? Oh, yes. Okay. So on this day, you had made an arrangement to go and see your child then, right?
She made an arrangement with me.
So you never reached out to her first?
She reached out to me.
She reached out to you, okay, so, but you still said, okay, I'm gonna go and see my daughter then, right?
Yes,
You went over there after work, they testified earlier, right?
yes,
Okay, and when you got there, you went to go and see your daughter, right, who was upstairs sleeping?
yes,
Okay. And after that, you brought her downstairs, right?
yes,
Was she still asleep at that time?
yes,
All right. And then there was an argument that took place between you and Miss Lavanu, right, about a key to the apartment?
more things too, but yes,
Okay, well, that was one of the things you argued about, right?
yes,
And you didn't want to give it to her because it's your apartment, right?
yes,
Because in your opinion, she doesn't have a right to have a key to the apartment that she lives in with her children, right?
she was moving out.
Well, at the time it wasn't though, right?
No,
The time it was active,
the lease was already expired and
it was expired, so you were allowing her to live there after at least that expires. Is that what you're saying?
yes, because she was moving out, she said,
Okay, so the apartment complex was aware that there's someone living in this apartment that's not on the lease.
yes,
Okay, that's what you're saying. All right, so you get there that day and you guys have this argument about that makes you angry, right?
no,
You didn't get angry about anything. Okay, so you're calm, having a conversation with her the entire time.
about the key, I wasn't upset,
Okay, but okay, other things then upset you then, right?
but
Yeah, you got upset, so you went at her, right?
no,
You never went at her. You never put your hands on her neck. Never choked her at all. Never lifted her off the ground with your arms around her and on her neck.
not that strong to lift the ground out, I would never,
Okay, so you never did that either. That's not true.
no, it's not true.
Okay, but so the only thing you did is grab her phone and smash it then, right?
I said, you grab my phone.
After she grabbed yours. So you grabbed yours in retaliation and you smashed it because you felt like it's your phone and you own it and you can do whatever you want, right?
Yes,
Okay. So, and this was done in front of her children there, right?
yes,
You felt like that was appropriate behavior to act like that in front of two children?
No.
You still did it anyway though, right?
yes,
Okay. One of them being yours, right? Okay, so it didn't matter to you at that point how that might affect them, right? You were just too angry to care about that. You were, okay, so you did snap the phone in a calm, nice manner, right?
father's very trying to get out.
Wanted to get out, so you did that. You just got out there and you left your child there, right?
Yes.
At that point, you didn't care, you just wanted to get out. Okay. And you're obviously aware that you're on probation for a case that you had gone to jury trial on, right?
Yes,
And is it important to you to keep up with the terms of this probation?
yes,
Because you want to be on probation.
yes,
You want to do well on probation.
yes,
And you felt like this was the appropriate way to show that you're doing well on probation?
that's why I wanted to leave. That date, that's why I was trying to leave.
You were trying to leave, even despite all this stuff, you were wanting to leave because of your probation.
Because she kept saying she was gonna call the police.
Did you ever call the police that day to tell them your version of what happened?
No, because I didn't hurt her, so I wasn't aware of anything. I just thought it was, I didn't hurt her, she didn't hurt me, I just thought we would just talk to each other, just blow it over and she'd apologize, because she always does, she'll apologize. And we try to co-parent, that's all I thought was gonna happen, I didn't hurt her, I didn't do anything, so I didn't think if anything was gonna happen.
All right. Any other questions?
From the state.
Any follow-up questions?
Not on the allegations on number one, Judge. No.
All right. Any other witnesses from either side?
None from the state.
Judge, I would have questions for probation, but not as to the truth or not untruth of the allegations of number one, just depending on if that's necessary. But I was assuming you were going to ask.
No, what questions you
Well,
have?
just like how he's doing on probation, whether he's all the things he's supposed to be doing, things like that. But
All right. All right, you're still under oath. Defense tells me they have some questions. They just want to know how Mr. Joines was doing on probation other than with this allegation.
Your Honor, he was doing fine, was showing up on time for his virtual visits. Unfortunately, he tested positive for cocaine and cardiac effects. Other than that, he showed up on time.
Well, but he's done more than that, to be fair, right? He's completed classes, correct? Matter of fact, you have a listing of all the things that he's completed. Tell the judge all the things he's completed on probation.
So he's completed matters of intervention, GPS. He provided a DNA sample on his parenting class.
What about community service?
Yes, he's completed community service.
Well, how's he done on those payments?
So he made payments. He does have a balance of $3,712.
Okay, but that includes probation fees that are due in the future, correct?
Correct.
How much is he actually paid towards probation?
So he's actually paid $244.
Okay. Now, isn't it true that you advised him that because of all the things he's completed, and if he got current with his probation fees, that he might be eligible for early termination?
Reject this testimony, Your Honor.
Overruled.
You didn't have that conversation with him? Okay. Who did he have before you? Or did he have somebody before you? Is better.
Yes.
Okay, so you've only been on the case just a couple months. Okay. That's what it should.
No questions, Your Honor.
Thank you so much. With regards to violation of condition number 2, the court is finding it not true. The court will note for the record that the probation officer did state that Mr. Duenas, I believe, tested positive, but the court is not considering that because I know that the defense was bringing the witness strictly for the purposes of how he was doing on probation and with regards to whether or not he tested positive for cocaine. Lab reports would need to be presented and the person, whoever is responsible for doing the testing, would need to come in and testify. So that'll be found not true. With regards to violation of condition number 1, the court is finding violation of condition number 1 true. Is there a request from the state?
Yes, Your Honor, that request is to revoke the defendant's probation and sentence him to 2 years in prison.
All right, defense.
Well, clearly, Judge, we're not in agreement with that. And now that you've heard the testimony in the case, you can see why we're anxious to take this case before a jury and get a determination after a full and complete trial of all of the issues with all of the witnesses and other evidence that's relevant and admissible in court. Due to his performance on probation, Judge, and his obligation in terms of support, his voluntary acquiescence to the protective order, we'd ask the court to employ one of the many sanctions that the court has available and to keep him on his probation. If nothing else, at least until we resolve that new charge. The state's going to have another shot at him. In that case, they can ask for the full range of punishment, and they won't be limited to the 2 years that the court has in this situation. I think Ms. Levana was honest when she said that it's a two-way street. And she was being very kind to herself about that. When you smash a pot over somebody's head and then embed glass into their shoulder, that suggests you the type of person that she really is. And why she admittedly was reluctant to come and testify in court because there's things that she's done and contributed to this situation happening in October that she's not proud of either. I think they both are embarrassed that all this had to come to light in public, and they both could have done better and handled the situation. And so, Judge, in light of everything, rest in the court not to revoke his probation and to consider other alternatives.
All right. And counsel, have you completed the trial court certification?
I have not, Judge. I've been kind of busy last week.
Oh, if y'all will complete that for me, please.
Limited rights to appeal.
All right. The court is going to grant the state's motion to revoke. The court will sentence you to 2 years in the prison, giving credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Danessa Duenas, Christian Rodriguez, and Charles Waterson. And that's from the previous conditions that were given when you were placed on community supervision by the jury. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? You do have a right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you're in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Okay? All right. Good luck to you, sir.
1 o'clock?
Hello, Mr. Sullivan.
All
right. All right. All right. The court is calling 2018 CR 8528 State versus Eddie Leroy Sullivan III. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Mr. Sullivan? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Eddie Leroy Sullivan III who was placed on deferred adjudication in 2018 CR 8528 for the offense of obstruction or retaliation on June 11, 2019 for a period of 5 years? Is that you? All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Eddie Leroy Sullivan III did then and there fail to report to the supervision officer as directed for the months of September and October 2024 in violation of condition number 5.
How do you plead to that? True or not true?
State will waive the remaining violated condition alleged.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. And counsel, it's my understanding that your client was found competent, correct?
Yes, Judge. And I was reappointed onto the case after that evaluation was ordered, but I haven't reviewed the order and was found competent.
All right. Is there a proposed agreement?
There is, Your Honor, the proposed agreement is to grant state motion to sentence Mr. Sullivan to 2 years in prison.
And there is also, Judge, a misdemeanor case he is going to plea on that case.
Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right. Why were you not successful on probation? All right. And that violation of condition number 5, that is in count 1 as well as count 2, correct? All right. So the court will follow your agreement. And are you waiving your right to appeal? All right. The court will follow your agreement, find you guilty, and revoke in counts 1 and counts 2, sentence you to 2 years in counts 1 and count 2. Give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Michael Ebrom, Ebrom, and M. Bennett. Counts 1 and counts 2 are to run concurrently. And our request, the therapeutic community, it doesn't increase the time that you've been in custody, but it will help with any addictions you may have. Yeah. So did you review? You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, Mr. Sullivan, when you're released from custody, if for some reason you cannot find a place that can help you maintain your sobriety, if I'm still here, you come back here and I'll make sure that I pick up the phone to call someone who can help you with transitional housing. But you got to want it. All right. All right. Good luck to you, sir.
Hello, Judge.
Hello. The clerk is going to swear in the defendant. So if you can just interpret everything that's being said for us, please.
Yes, Judge. I do.
All right, you may proceed.
اخي لاس دې چیک کړه وروره او ووایه چې هر څه وایم درته قاضي وایي. Okay, Judge. He wants to say like I raise my hand. I want to. What should I say?
No. Could someone speak into the microphone so she can hear, please?
Yes, ma'am, I need to swear him in. Can you please repeat his name? I believe it's Abdul. I cannot pronounce his full name.
وروره وایي مازې لاس ښکته که مازې راته ووایه چې ستا مکمل نوم څه شی دی. عبدل پوهېږم خو تخلص دې نه پوهېږم. مکمل نوم دې راته ووایه وروره.
Imam Abdul Ghaffur, last name Onufial Worth.
Did you get it?
Yes, I did. Thank you. Mr. Gould, please raise your right hand. Do you solemnly affirm that the information that you have gone over in these documents is true and correct to your best knowledge?
وروره وایي دا هر ټول معلومات چې تا ته درکړل شوي دي او تا چې موږ ته راکړي دي خپل معلومات وایي تاسو قسم وخورئ چې دا هر څه تاسو ویلي دي هر څه صحیح دي د صحیح نه بغیر بل څه نشته.
او دا هر څه ما صحیح ویلي دي. انګلیسي د یو ټیم نه په دغه هیمالیا راته ویل ما.
Yes, everything, all the information I have said, it's true. There's nothing without truth.
Mr. Cole, do you understand by signing the waiver that you gave up your right for having a jury trial, sir?
وروره وایي دغه ورقه چې ما درته وویل او تاسو امضا وکړله وایي په هغې باندې پوه شوې که نه؟
او پوه شوم ډېر ورقې راته وویلې.
Yes, I understand. And there was like too many papers I have signed and all I understood.
Thank you. I'm going to verify your signature now.
اوس زه درته ستا امضا ښیم.
This is the plea paperwork that you went over with your attorney?
دغه اسنادونه دي دغه مغه ورقې دي چې وکیل سره تا مخ ته ویوړه.
Yes.
Yes, Judge.
Is this your signature here, sir?
دا ستا امضا ده وروره تا امضا کړې ورته.
دا زما امضا ده.
Yes, that is my signature.
Thank you. This is the actual plea bargain paperwork, sir, that you went over. Does everything look true and correct? And are these your two signatures here, sir?
دا هر څه چې درته معلومات ویل شو هر څه رښتیا دي او ته پې پوه شوې یې او دا ستا دوه امضاګانې دي چې تا خپله کړي. آیا دا صحیح ده؟
او دا صحیح دي. په د انګلیسي باندې خو زه نه پوهېږم. د امضا زما دی. ما سترګې لري امضا زما ده. او
Yeah, so the signatures are mine because right now there's in English. I can't read it.
I understand. Thank you.
ما پوه شوم وروره مننه.
He did go over everything with an interpreter for the plea bargain agreement, ma'am?
Yes, Judge. Yes, ma'am.
Thank you. This is the waiver that you gave up your right for having a jury trial. Did you go over this in the language that you understood?
وروره وایي دغه ټول هغه وکیل چې تا ته درته کوم خبرې درته وکړلې او ما تا ته تشریح کړله وایي هغه څه دي چې درته ویل شوي دي هغه صحیح ده پې پوه شوې یې؟
او زه په پوه شوی یم هغه صحیح ده.
Yes, I understood.
Thank you.
مننه.
Is this your signature here on this waiver?
دغه وګوره دا هم ستا امضا ده وروره.
او دا زما امضا ده.
Yes, that's my signature.
Thank you. And there's one more right here, sir. Is this your signature?
دلته یو بله وسه کړم دا وګوره دا هم ستا امضا ده.
او دا زما امضا ده.
Yes, that's my
Thank
signature.
you very much, sir. We can continue. Thank you, Judge.
مننه کوم وروره.
Oh, you can lower your hand, sir.
لاس دې ښکته کړه وروره.
Norma, what page is he on?
1 second, Judge. He's on page 10. 4 down.
All right, the court is calling 2025 CR 011985, State versus Abdul Ghaffur Khan Konifa Gul.
وروره وایي تاسو نوم مو اوس غږ کوي چې 25 کال CR 011985 عبدالغفور خان.
All right, could I have parties announced for the record for the state?
اوس یو نفر راځي ریکارډ کړي د سټیټ ته طرف نه.
Lord Espinoza for the state.
For the defense?
David Rodriguez for the defendant.
All right, and he just stated James Rodriguez for the defendant. Everybody's going to have to speak up so she can hear. I'm sorry, David Rodriguez for the defendant. I need everyone to keep their voice up.
دا وکیل چې دی دا خو ته پیژنې دا ډیوډ دا ستا وکیل دی ښه مدافع وکیل.
All right, and we have an interpreter by Zoom. To the interpreter, could you raise your hand for the court, your right hand?
Yes, Judge, I do.
Do you solemnly swear and affirm you will faithfully translate from English into Mr. Gould's language and from Mr. Gould's language into English?
Yes, Judge, I do.
All right, you can lower your hand. And can you tell the court what is Mr. Gould's language?
It is Pashto.
All right, thank you.
Thank you, Judge.
All right, Mr. Gould, all of the documents that I'm going to review with you are in English. Were those documents explained to you in your language?
عبدل وروره وای د قاضي وای چې زه دا ټول اسنادونه چې دی یو ځل بیا د مرور د پاره په انګلیسي درته وایم او زه به ته ترجمه کوم وروره صحیح شو؟
صحیح.
Okay.
What's the answer? I need a yes or no.
وای چې ماته جواب راکړه چې هو راته ویل شوی دی او نه راته نه دی ویل شوی.
هو.
Yes. Were the documents explained to you in your language?
وروره وای کوم اسنادونه چې درته تشریح شوي دي د انګلیسي څخه پښتو ته آیا تاسو ته ترجمه شوي دي که نه؟
ترجمه شوي دي خو د اسنادونو مقصد دومره واخله ټوله ته ترجمه دي.
Yes, all documents were translated.
All right. Did you, counsel, did you receive all the discovery and review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it?
وای کم خبرې اترې چې کم جزئیات چې وکیل درته وړاندې کړل خپل وکیل په خبرو هر څه باندې پوه شوې؟ Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
خپل وکیل سره چې د هر څه په باره کې در سره خبرې وکړل هغه باندې پوه شوې؟ Yes, Judge, I understood.
Counsel, do you waive the reading of the indictment?
I do, Judge.
I need the interpreter to repeat that, please. Counsel,
Yes, Judge.
Counsel, do you waive the reading of the indictment?
وای آیا ته دغه جزئیات چې درته وړاندې شو دي ته دوباره درته تاسو تشریح کوي صحیح ده؟
صحیح.
Okay.
No. Defense attorney, do you waive the reading of the indictment?
I do, Your Honor.
All right, and if you could repeat that to the interpreter, please.
وکیل ته وای چې دا هر څه دې ورسره خبرې اترې دي کړي مرور کړي دي د دوباره هغه ورته هغه وکیل ویل چې و ما کړی.
State, are you proceeding on the indictment as presented?
او هغه بل چې دی هغه بله ښځه چې ده هغوی هم وایي هغې ته یې وویله چې مثلا تا هم د دوی سره برخه اخیستې ده دوی ورته وایي چې هو.
Yes, Your Honor.
او وایي.
Right. Did you review the court admonishments with your attorney, Mr. Gould?
تا هم وایي خپل دغه ټول جزئیات خپل وکیل سره هر څه خبرې اترې دي وکړې ورسره که نه د وکیل سره؟
ما ټولې خبرې ورسره وکړې.
Yes.
Right. You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
وروره وایي ته په دې پوه شوې چې مثلا ستا په هغه شی کې چې تا پیدا کړی و هغه د 1 ګرام څخه مثلا کم یو تقریبا 1 ګرام اندازه و مواد مخدره ټوکي وي چې هغې دا چې دی فلاني یو جرم دی او همدارنګه د دې باعث کیدی شي دا جرم چې تا د مثلا 100 نه تر 2 کالو پورې تا جیل ته ولیږي او همدارنګه $10,000 پورې جریمه در باندې راشي.
او دغه خو ما پیدا کړی و نور ما لیدلی نه دی چې 1 ګرام و څومره و خو ډبه یې ما راواخیستو پیدا کړو. زه ځان نه مجرم ښیم نه ځان نه زه صحیح ښیم.
Yes, that is correct. But I have found that, but I didn't know how many gram were in there, what was inside that box. I just found it.
All right, do you want a jury trial?
اورورا وای ته غواړې چې هغه چې وکیل چې درته ویله ما خبرې باندې کومه عریضه کوي که نه
او وکیل چې سره ته وویله خبرې زه منم.
I talked with the attorney and I agree with him.
So do you want a jury trial or do you want to enter into this plea bargain agreement?
لکه ته غواړې چې د هماغه شیان چې وکیل درته ویل ته په هغې باندې راضي یې که ته غواړې چې بله عریضه وکړې
دا زه په هغه باندې راضي یم وکیل چې سره ته وویل.
I follow my attorney's agreement.
All right. Do you understand you have a right to jury trial for your attorney or you to cross-examine any witnesses the state would call in the right to remain silent?
وروره ته په دې باندې پوهېږې چې دا ستا حق دی چې مثلا وکیل یا کوم بل شاهد چې راشي او مثلا معلومات تحقیقات وکړي چې تا رښتیا هغه کار کړی دا ستا حق دی ته غواړې چې هغه په خلاف وجنګېږي یا نه وایي څه چې وکیل درته ویلی چې هغه مخته وړې
زه خو څه چې وکیل راته وایي هغه زه منم نه راته زه خو ولا ښه پوهېږم.
I understand and whatever my attorney say the instruction, I will follow that. And other than that, I don't know.
All right. If the court grants your application for deferred adjudication, if you're revoked, the court can sentence you up to 2 years in the state jail facility. Did you understand?
وای که چیرې محکمه مثلا دغه چې شیخ خپل هغه اعلان کړي چې دغه رضایتمندي ونه مني یا ته په دې پوهېږې چې خدای نخواسته تا 2 کاله جیل ته لیږي
زه به څه ووایم دی قانون وي هغه قانون زه عملي کوم.
Yes, so whatever the law says, I follow that.
My question is, did you understand that?
وای مطلب ما پوښتنه ده چې ته په دې پوهېږې فقط هو ورته ووایه.
Oh.
Yes, Judge.
All right. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
کله هم تاسې څوک ځورولی یاست دغه کړي یاست چې مثلا تاسو ته اختاریه درکړې یا بل کوم ځورونې در سره کړي؟
نه.
No, Judge.
Has anyone promised you anything other than the plea?
لکه بل څوک د پلي نه بغیر لکه وایي چې عریضه نه بغیر وایي تاسو ته کله هم پیشنهاد کړي د پیسو که نه؟
نه.
No, Judge.
Are you satisfied with the way you've been represented?
هر څه چې ته وړاندې کوې موږ ته دې وړاندې کړي دي په دې باندې ته راضي یې؟
خو په دې باندې زه راضي یم خو دغه یوه خبره چې د ډبای ما موندلی وه زه خو دا نه شوم پوهې چې 1 ګرام کې دي څومره کې دي خو دا مو موندلی وه مقصد دا کې زه نه ځان مجرم ښیم نه ځان صحیح ښیم.
Yes, Judge, I understand. And the other thing I want to mention that the box that I have found, and I didn't know, I don't know like it was 1 gram or how much, but I just found it. And then other than that, I want to add that I not feel guilty or not feel not guilty, but I feel no contest.
That's not my question. I need you to listen to the questions that I'm asking of you. Do you understand?
وای دا زما پوښتنه نه ده وای زه غواړم ته په دې پوه شې چې کوم پوښتنه زه درنه کوم هغه جواب ورکړه ته په دې پوهېږې؟
په څه شو باندې؟
Okay, Judge, can you repeat it?
Inshallah, do you understand?
ته پوهېږې وروره؟
Oh.
Yes, Judge.
All right. If you're not a U.S. citizen, by entering into this plea, you can be deported, denied re-entry, and naturalization. Do you understand?
وای ته که چېرته وایې مثلا ته امریکایي پاسپورټ دې نه اخیستی اوسه پورې یو سټیزن شوی نه یې نو په ته به کیدی شي وشړل شي د دې ځای نه او یا هم ستا هغه کومه ورځ باندې چې ته اپلای کوې هغه ورځ باندې وایي تا د دې ځای نه لرې کړي هغه دغه کینسل کړي درته او همدارنګه ته به د دې ځای نه وشړل شي ته په دې باندې وایي پوهېږې که نه؟
زه په دې باندې پوهېږم زه چې کته پاسپورټ ته اپلای کوم ماته ویل شوي چې انګلیسي دې نه وي زده زه کوشش کوم چې انګلیسي مې لږه لږه زده کړې وي زه کوشش کوم چې انګلیسي زده کړم دغه یو څو کلو کې بیا اپلای ورته وکړم.
Yes, yes, Judge, I understand this all, but I'm trying to get my passport as soon as I can because for the passport I have to have learn English to speak more English. So for that I need time to learn English. Then I can go ahead and apply for citizenship.
Okay, I want you to listen to what I'm saying. And I want you to answer the question that I'm asking of you and nothing else at this point in time. Do you understand?
وروره قاضي چې دی تا ته وایي کومه پوښتنه چې درنه کومه هماغه جواب راکړه اضافي خبرې پکې مه کوه فقط دومره درته وایم چې څه درته وایم جواب یې راکړه اضافي خبرې ته پوهېږې په دې باندې پوه شوې
صحیح شوه پوه شوه.
Got it, Judge.
All right. If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported. Do you understand?
که چیرې وایي ته یو اس سټیزن یا د امریکا شهروندي دې نه یې ترلاسه کړې که چیرې ته مثلا همدا بیا عریضه وکړې او ته نه یې بیا کیدای شي ته د دې ځای نه وشړل شي ته په دې پوه شوې که نه
پوه شوه.
Got it.
You will be denied naturalization. Do you understand?
او که چیرې ته مثلا ولاړ شې هلته نیچرلایزیشن هغه ورقه چې ستا نوم شان درکړي د پاسپورټ په ورځ باندې هغه هم به رد شي ته په دې پوه شوې
پوه شوه.
Yes, Judge.
You will not be allowed back in the United States. Do you understand?
ته به بیرته واپس امریکې ته ونه راوړل شي ته په دې پوه شوې
پوه شوه.
Got it, Judge.
Counsel, have you been able to communicate with your client through the interpreter?
وای تا وکیل سره خبرې وکړې د ترجمان سره وکیل ته وای تا خپل تا سره خبرې کړې د ترجمان سره که نه
ما سره خبرې کړې.
Now, it's for your attorney to answer.
دا وکیل خبر جواب ورکړي ته غلیک شه
Yes, I have, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? I need you to interpret that.
وکیل نه پوښتنه وکړله وکیل ورته ویل چې هو ما خپل خبرې اترې ورسره کړې دي او بیا وکیل نه پوښتنه وکړله چې آیا تاسو د تا ښې دا په دې باندې پوه شوی دی چې دا کیس ستا په خلاف دی تا داسې کار کړی دی او اوس هغه وکیل جواب ورکوي
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
وکیل ویله چې هو کړی دی او بیا ترې نه پوښتنه وکړه چې دا قانوني خبرې ورسره کړې دي په قانون باندې پوه کړې که نه یې پوه کړې اوس وکیل جواب ورکوي
I do, Judge.
Court will find.
Sorry.
I'm sorry, go ahead.
وکیل ویله چې و ما کړی
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
وایي چې محکمه کې مثلا اضافه خبرې باید ونه شي کم کسان چې والنټیر رضاکارانه کارم باید وکړي دا هم درته ویلي وو اوس وکیل جواب ورکوي
All right. According to your plea bargain agreement, the state is recommending deferred adjudication and there's an $800 fine. Did you understand?
وروره اوس ته جواب ورکړي چې مثلا د ټولو شیانو په مطابق باندې وایي سټیټ چې دی دا تصمیم ونیول چې دا د $800 به ته جریمه ورکوي په دې باندې پوه شوې
پوه شوم. صحیح.
Yes, understand, Judge.
To both counsels, is that the plea?
دواړو ته وایي آیا دا عریضه صحیح ده دواړه ویل چې هو صحیح ده
By signing this waiver of appeal paragraph twice, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
د دواړو طرف نه په آخر کې دا ورقه امضا شوه چې مثلا د کوم عریضه چې تا کړې وه دا ستا هر څه د هغې سړي سره تا خبرې کړې دي او په دې باندې ته هر څه باندې پوه شوې صحیح ده
صحیح ده پوه شوم.
Yes, understand, Judge.
Counsel, have there been any such motions?
No, Your Honor.
او قاضي پوښتنه وکړه چې دا کوم احساساتي خو نه دی هغه ورته وویل چې نه دی.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service, the DOEP course, and random UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
وروره د ایالت یا د سټیټ څخه دوی وایي دا تا نه وړاندیز کړی دی چې ته به 100 ورځې ته به مثلا کومکي کار کوې رضاکارانه کار کوې پیسې به نه اخلې او همدارنګه د ډي او پی یو صنف دی چې هغه باید واخلې او دا چې دی ټول د سټیټ لخوا څخه تا ته وړاندیز شوی دی چې محکمه چې دی یا کوټ وایي په دې باندې څه ویل نه لري.
نه پوه شوم بس په دې باندې زه څه ویل نه لرم څه.
Yes, Judge, I got it.
All right, then how do you plead? Guilty, not guilty, or no contest?
نو اوس په اخر کې تا نه پوښتنه کوي چې ته ځان ګناهګار احساسوې بې ګناه احساس کوې که هم هغه دریم چې تا ته هغه سړی ویلی و نو کانټیسټ.
زه ځان نه بې ګناه حسابوم نه ځان ګناهګار حسابوم د کیس په مقابل کې.
So not guilty, not you chose the no contest option.
All right, state any evidence.
کوم شواهد؟
Yes, Your Honor. State offers States Exhibit 1 and all attachments.
محکمه چې د سټیټ چې دی دوی ته نه دا وړاندیز کوي چې درته څه وویل غواړي اوس درته وایي.
No objection, Your Honor.
اوس وکیل زر خبرې کوي.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it?
هغه کوم ورقه چې در باندې وکیل امضا کړله وایي خبرې در سره وکړلې په هغه باندې پوه شوې؟
پوه شو.
Yes, Judge, understood.
You have a right to jury trial, a right for your attorney to cross-examine witnesses, and the right to remain silent. Today, the state is going to be presenting evidence with just police reports and documents. Do you understand?
وایي ته په دې باندې پوه شې چې ته به ځان غلی نیسې که چیرې شواهد ستا په خلاف پیدا شو او په پولیس راپور ورته ورغله تر هغه وخته پورې ته به ځان غلی نیسې ته په دې پوه شوې؟
پوه شو.
Yes, Judge, understood.
All right, the court will accept into evidence state's exhibits. The court will find that the defendant has voluntarily stipulated to the testimony. The court has reviewed the same. The court will find that there's sufficient evidence to find you guilty and defer finding of guilt.
وایي محکمه به په آخر کې دا اعلان کوي چې مثلا د شواهدو په نظر کې نیول سه تر څو چې شواهد پیدا شي چې ستا په خلاف باندې محکمه به دا اعلان ورکوي په آخر کې چې مثلا یا به ته په شواهد نه وروسته یا به ته ګناهګار ثابتې یا به بې ګناه هغې نه هغه به وروسته خبره ده. Got it, understood, Judge.
Are we proceeding with sentencing?
Yes, Judge.
Anything to say on behalf of your client?
Only that I would urge the court to follow the plea bargain agreement.
You may repeat that.
قاضي پوښتنه وکړه چې ته څه ویل غواړې ستا خپل د دغه ستا په وړاندې باندې ستا په حساب باندې دی ورته ویل چې غواړم زما ستا په باره کې څه ویل غواړي د خپله خبرې کوي.
All right. Do you have any children?
ماشومان لرې وروره؟
نه ماشومان زه نه لرم.
ماشومان sorry I couldn't hear. Can I ask you one more time?
Yes.
وروره ته بچي لرې؟
نه ما بچي نشته.
No, I don't have.
Court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, $800 fine. That will be probated.
Aurora?
Sorry, just 1 second. 120 hours of community service restitution and TAP evaluation out of custody, follow TAP recommendations. You may repeat that.
قاضي وایي چې کنه وایي دلته چې دی وایي مثلا ته چې یې مثلا یا کار به کوې 15 ورځې یا مثلا ته د جیل څخه وتلو وخت کې غواړې چې ووځې 120 ورځې مثلا ته باید کومکي رضاکارانه کار وکړې خلکو سره چا سره هر بخش کې دي چې کوله او همدارنګه وایي چې $800 دغه جریمه به ورکړې.
Probation, is there anything else? Field visits 1 time per month until further notice.
وایي میاشتې کې یو ځلې باید تاسو وګورو. So per visit is monthly, sorry, Judge.
Field visits 1 time per month until further notice.
وایي چې یو میاشتې د میاشتې یو ځله به دوی تاسو سره ګوري. Okay,
All right. Is there anything else you need from the court to be successful?
وروره وایي داسې څه نور غواړې د محکمې په وړاندې باندې چې څه ویل لرې؟ No, thank you, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, and did you sign it?
هغه ورقې چې درته امضا کړلې وایي هغه دې وویله مرور دې ورباندې وکړلې چې مثلا کوم حقونه ستا دي هغه ټول د وکیل سره که نه؟ Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
او په دې خاطر چې ته د هغې ورقې شان دې امضا کړي دي په دې باندې هر څه پوهېدلې نو وایي محکمه په دې کې تا سره غرض نه لري نو خپل عریضه دې خپل هغه وکیل سره به خبرې وکړي وایي په دې باندې خو ته پوهېږې که نه؟ Yes, Judge.
All right. Thank you. Interpret, if you'll stay on the line. Vashawn, what do we need to do with the interpretation?
Mr. Kimbrell is going to log on to Zoom. If she could interpret for you, that would be great.
All right. Thank you. All right, sir, just have a seat. We're going to make sure that probation goes over the conditions with you in your language.
وروره وایي کښېنه بیا هغه نظارت کوونکي یا څېړونکي افیسر راځي بیا هلته بیا ستا سره خبرې کوي زه به ترجماني درته کوم ته هلته کښېنه بیرته.
All right.
Thank you, Judge.
To the interpreter, oh, thank you so much. I think the language is beautiful. I'm going to work on my skills with it. I'm sending you to breakout room number 1, and someone from probation will meet you there.
I appreciate it, Judge. Thank you so much. I'm Joy.
Court is calling 2025 CR 012039, State versus Nicholas Salazar. Can I have the parties announced for the record for the state?
Lauren Espinoza for the state.
Defense?
Attorney John St. Hunters from Mr. Salazar.
All right. Counsel, have you received all discovery? Did you review it with your client?
Your Honor, I believe so.
Court will find that the state is in compliance with discovery. Mr. Salazar, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Salazar, did you review court admonishments with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by signing that? I'm sorry. Oh, no, that's yours.
Oh, sure.
That's okay. You reviewed the court admonishments?
Yes, Judge.
And did you sign it in all the appropriate places?
Yes, Judge.
You understand you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
Nothing.
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Oh, sorry, is something going on back there?
Yeah. It's just,
Okay.
it's just me talking about.
Not that we're calling anybody out.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, there's $1,000 fine to be probated and the state recommends deferred. Did you understand that?
Yes, Judge.
Counsel, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I believe it is. Yeah, you're right.
State, any evidence?
Your Honor, state offers states exhibit 1 and all attachments.
Did you review the waiver? Oh, any objection?
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
I would ask that the court follow the plea agreement as negotiated between the state and my client.
All right. Do you have any children?
No, Your Honor.
Do you live with any minors in the household?
No, Your Honor.
Do you live by yourself?
I just have 2 dogs. It's just
Oh, okay. What type of dogs?
husky and a Catahoula.
Oh, Husky in San Antonio. That makes for hot times. All right. The court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, 120 hours of community service restitution, probation. You conduct an hour for every sober support meeting that is completed. There's $1,000 fine that will be probated. TAP evaluation, out of custody, follow recommendations. If you're drug tested today, what would the results be?
Be clean, Your Honor.
All right. All right. Probation. Is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor. I'd just like to ask the court for one thing on the record, Your Honor. My client is a cook at a restaurant. His take-home pay is slightly less than $3,000. I would ask that the probation fees be set to the statutory minimum.
Oh, he'll have to provide proof of that, and then the court will make a consideration on that.
Thank you, Judge. I appreciate it.
All right. And where do you cook?
At a downtown restaurant, steakhouse.
All right. And what is your specialty?
Well, I do the saute and prep.
Okay.
So a little bit of everything.
All right. Awesome. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you've waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Make better choices. Good luck to you.
Thank you.
Thank you.
Judge, thank you for the court's time. I appreciate you, Your Honor.
All right. Thank you.
Merry Christmas.
Merry Christmas to you too.
May I please be excused?
Yes. Court is calling 2025 CR 011513-02 and 2025 CR 011514, State versus Ruben Martinez. Can I have parties announced for the record?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Martinez?
Yes.
And each of the cause numbers, did you review with your attorney the application for deferred adjudication? Did you understand it and sign it? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
And we did review.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the true bill of indictment with your attorney, Mr. Martinez, and did you understand? Counsel, do you waive the reading of the indictments in each cause number? In each cause number, state, are you proceeding on the indictment as presented? Mr. Martinez, in each cause number, did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places? And cause number ending in 02, you're charged with obstruction or retaliation. And cause number ending in 14, you're charged with terroristic threat or impersonation of a public servant. Both of those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did understand.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Here we go.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Here we go.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine in each cause number?
I do.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Martinez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
In each cause number, the cases ought to run concurrently. The state is requesting that your fine be set at $1,200. The state is silent on your application for deferred adjudication. They're recommending community supervision. Did you understand that to be the plea in each of these case numbers?
Yes.
And in one cause number, they're taking in consideration 2025 CC 013418. Did you understand?
Yes, sir.
Defense is at the plea?
Yes, sir.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of these cause numbers with your attorney? Did you understand it and sign it in both places?
I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
Counsel, are there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be 120 hours of community service restitution, mental health evaluation, MRT, and parenting classes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then in each offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State offered State's Exhibit 1 and all attachments in both.
No, Judge.
All right, state, have you had a chance to speak to any complainants?
Yes, Your Honor.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there will be no live testimony? Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Your court will notice that this offense took place around Father's Day. It was around Father's Day when the mother of his child, who was living in San Antonio, and my client was in El Paso, the mother of his child was denying him access to his son, was not allowing him to have contact with his son via phone. He, in an extreme moment of frustration, he called the non-emergency SCPD number and made a series of inappropriate, criminal, and hostile remarks on recording on 911. His goal was to get 911 and officers to his the location of his son. Unfortunately, he did not know the location of his son or the address of where he was staying. That is to the degree that the mom kept information from him. As he's making these calls, he became incredibly frustrated, which is no excuse, but it is a description of what he was going through. He made a series of calls, and he which were inappropriate, and he totally lost a sense of what was appropriate. So given that circumstance, he realizes, number one, that he accepts that he just made a decision to have a relationship and have a child with somebody that behaves this way. He realizes that his behavior is incredibly inappropriate. He realizes that it was criminal. And as a result, we have negotiated with the court's approval the probation. I have taken a step further, and we're asking the court for deferred status. He does not have a criminal record. He is 45 years old. He does not have, he does have some formal education.
So does he live here in San Antonio or is he in El Paso?
At the moment, he lives in San Antonio. Now, if he has expressed to me that if he does take steps, if he begins to struggle again in San Antonio financially, he's going to move back to El Paso with his mom.
But here's the thing, you're not allowed to move anywhere unless you receive permission from the court. Do you understand?
I do.
All right, so this is what the court will do. And what is the name of the mother of your child?
Sadie Kirsch. SADIEAIRAIRSCH.
Sorry, A-R.
The
The last name.
KIRSCH.
This is what the court is going to do. Court is going to sentence you to 8 years deferred adjudication in cause number 2025 CR 011513-02. There's a $1,200 fine that will be probated. This will run concurrent with 2025 CR 011514. Taking consideration 2025 CC 013418. There's to be 120 hours of community service restitution. 100 of those hours we deem satisfied upon completion of anger management. The remaining 20 hours will be deemed satisfied upon completion of parenting. There's to be a MIC evaluation in custody. There's to be no contact with Sadie Kirsch except through the parental portal. Proof of employment within 45 days of a release. No employment as a home health care provider or with minors. Field visits one time per month until further notice. Probation, is there anything? Just one, sorry. There's to be regular reporting by Zoom or in person and regular random UAs. Probation, is there anything else?
Okay.
Is there anything else you need from the court in regards to that cause number?
A question, Your Honor. Were me and my wife are already using a parental app since we're going through.
Well, that's what I'm saying. You'll have to contact, you're only allowed to contact her through a parental app. If you all are in court for civil hearings, of course, you can proceed with that. All right. And cause number 2025 CR 011514. The court will sentence you to 8 years deferred adjudication. $1,200 fine probated. This is to run concurrently with 2025 CR 011513-02. 120 hours of community service restitution, 100 hours deducted for completion of anger management, the remaining 20 deducted for completion of parenting classes, NIC evaluation in custody, no contact with Sadie Kirsch except through the parental portal, proof of employment within 45 days, no employment as a home care provider or with minors, field visits 1 time per month until further notice, and regular reporting by Zoom or in person, and regular random UAs. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I do, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do, Your Honor.
You have to make better choices, right? I know that custody issues, people get heated with that, but you can't do that. You'll have to use the legal system. You understand? All right, good luck to you. Thank you. All right, counsel, are you proceeding on the motion to revoke?
Your Honor, it's our understanding that the state, in conjunction with probation, are asking that he be terminated unsatisfactory.
All right, so does anyone have any paperwork for me?
I didn't know if we were gonna just move forward with NCR or if we're gonna withdraw and ask that the court go along with the.
Do y'all want to withdraw?
Sure. I think the consensus, if the court's okay with that,
All right.
we're allowed to withdraw.
And so the mental health issues have been addressed?
Yes, Judge.
Okay.
Regarding that, Judge, speaking to my client more depth, like he did tell me that he suffered a hit and run in his mid-20s, and that left him with the traumatic brain injury, as well as rods having been placed on the right side of his whole body. So he's been experiencing chronic pain. He's looking to get that addressed medically, and also to see a doctor. He has an appointment to see a doctor next week to address his physical issues, Judge.
Okay.
And that's why he missed a couple of the drug tests. But other than that, Judge, no usage. His sister is his payee. He gets disability for his issues.
Okay.
And she also attested that there's no issue to drugs, and he's been on since 2017, Your Honor.
Okay. All right. All right. Thank you. All right. What is happening with your case?
This is Mr. Quinones' first time in court on this case.
Okay.
He was supposed to be here on the 10th of October, but there was some confusion. Both myself and Mr. Jeffrey Scott are representing him, and we kind of just got crossways. Our wires crossed on it. I'm on the bond. What I'm asking the court to do is consider withdrawing the judge's warrant, giving us some time to come back and review the case together, consider the offer. But I've already conferred with the state about the case and about a possible offer.
All right. So because of the changes in the law, we'll have to have a full-blown hearing, and I can't do that today.
Okay.
We can have it referred to Judge Nahara for a hearing on that.
That's fine.
Because tomorrow I have mental health court issues to take care of. All right. Ms. Ferguson.
Yes, ma'am.
They want a bond on this case. So refer that to Judge. They're asking for a reinstatement of the bond. You need to refer that to Judge Nahara or Judge Halstead.
Yes, ma'am.
Judge, my question was the bond was a bond forfeited?
It was a judge's warrant.
Right. So would we just, since my understanding procedurally, we would just need the court to withdraw the judge's warrant.
The bond laws have changed. So I can't just withdraw the warrant. There has to be a hearing.
Okay.
All right. All right. So what we can do, Norma, see if you can see if Judge Nahara or Halstead is available for tomorrow. If they're not, I'll take it up tomorrow.
Okay.
All right. Thank you.
Well,